have two opportunities to submit evidence. First, when you submit your first appeal, and second, at any time before your appeal hearing, so long as the referee and employer receive the evidence before the hearing. You can simply attach evidence to your written appeal, or you can mail other evidence before the hearing to both the appeals office and the employer. The appeal hearing notice has instructions on how to do this. Remember that after the hearing, you won't be able to submit any new evidence. What is evidence? Technically, your testimony and the testimony of other witnesses is evidence. But here we're talking about other forms of evidence that would help you show you should be eligible for benefits. It could be work documents, emails, text messages, audio or video recordings, or anything else like that. Let's talk about best practices for evidence. First, the best evidence to submit is direct evidence rather than hearsay. Direct evidence represents personal knowledge from the person who created it. For example, an email from your boss saying you were terminated is direct evidence that you were terminated, whereas a text message from your coworker saying your boss told her you were terminated is hearsay because your coworker doesn't know personally whether you were terminated. She just heard it from someone else. In a court case, hearsay isn't allowed, but in unemployment appeal hearings it is. That said, the referee will give more weight or deference to direct evidence than hearsay evidence, so try to submit as much direct evidence as you can, including when you provide your verbal testimony. Stick to providing what you know and what you can prove others know. You'll also want to make sure the evidence you submit is authentic and includes important information about it. For example, if you submit a document from your doctor, you want to make sure the whole document is there, that everything is visible and legible, and that it includes your doctor's signature, contact information, and the date it was signed. A common problem I see is with emails and text messages. You can submit these as evidence, but make sure they clearly show who sent the message, to whom it was sent, and the date and time it was sent. Make sure everything is legible and that you include the entire message. With text messages, sometimes it's good also to include a message or two before and after the message you're submitting to show you're not leaving out relevant parts of the message chain. The general point here is that you don't want to give the referee any reason to exclude or ignore your evidence because it's incomplete, difficult to understand, or otherwise does not seem legitimate. Give yourself the best possible chance of winning by submitting evidence that best supports your case and is as easy to understand as possible. One final note is that some people want to use evidence submitted by the employer in a separate lawsuit against the employer for something like a wrongful termination case. Unfortunately, Nevada law specifically states that evidence from unemployment hearings cannot be used for anything other than unemployment hearings. So even if your even if your former employer provides some evidence that that would help you in another case, you would need to get access to that evidence through a lawsuit or other means.